So when we first start looking after a client, the initial step is to really understand the circumstances, and in particular what the level of communication is between our client and their partner, because that will very much determine the pathways that are open to the client and understanding what their particular circumstances are. For example, if I speak to a client for the first time and they indicate that they've got a really good level of communication with their partner, that they've decided to separate but it's amicable, often I'll just be given instructions as to what the settlement is hoped to look like, and I will confirm whether that's within the parameters of the law, and then making sure that settlement is documented in a way that is binding so that the parties can move on and know with certainty that they can live independent lives, obviously continuing to parent together if they've got children, but financially that they can move ahead independently. Occasionally I'll have clients that ring and say, look, I sort of know what I want, but I'm not 100% sure. I think I could negotiate a settlement directly with my partner, but I'm not quite sure what the parameters are. And then my role, or the role of our team, will be to work with you and to give you those parameters, to not represent you in a formal sense, but to meet with you, explain how you can go back and negotiate. And often clients will come back and say, yes, we've reached agreement, and again we just go through that documentation process and make sure that the agreement is in a binding form. Often though, it's a client that says, I have no idea what's happening, I don't know what the parameters are, and I'm not confident enough, or the communication is not good enough with my partner for us to be able to resolve it on our own. And that's where we take a more formal role with you, partnering with you, but really aiming to meet a mediated settlement. That's the idea, that we get to a point that we have all of the facts, we've investigated the background, and we've got a very firm basis to then move into a mediated phase, which is a confidential phase. It's not in a court, and more often than not matters will settle at a mediation. The third common pathway is one that's often not of a person's choosing, and that's when their partner decides to commence litigation at a very early stage. It can often be very hot, it can be very urgent, it can be deeply unsettling. And that's where our skills really come to the fore, and we can help you to understand what steps need to be taken. We partner with you and stand beside you through that process. But just because you've begun on a litigious path doesn't mean that that's where you stay. Most matters will still resolve by agreement, but it might take a little bit of time before that happens. A litigious pathway is not one that should necessarily be feared. Sometimes you need some assistance from the court, particularly if you can't get information in relation to financial circumstances, or if you need certain orders to be made, such as if you're running a business and you need to be able to continue operating that business in the settlement phase before you reach a resolution as to how the assets are going to be divided. Often in circumstances that are very complicated, where you've got significant asset pools with detailed corporate structures, self-managed super funds, often that investigative phase is lengthy and it can take some time to get all of the facts together. Sometimes some help from a litigious point of view is valid, and that's where litigation makes sense, but it doesn't mean again that you stay on that pathway. We always try and aim to then move out of that litigious phase once you've got the tools that you need to move on and get back into a mediated phase. But occasionally matters do run to trial, but they are really rare. Most matters will settle at a mediation, and even matters that are running through court, in the matters that we run in our team, less than 1% of matters will conclude at a final hearing with a judicial determination. So the bottom line is, you don't need to make these decisions alone, and you certainly should not assume that you're on a litigious path. There are many ways to resolve a matter, and that is a rare pathway. You need to be confident that you can speak to us and speak with our team as to the pathway that is best suited for you and for your family, and we'll support you in that decision, and we'll also offer alternatives that you may not have even considered. It's really important that you're confident and that you know that our team is with you and guiding you through the process, and that we're with you on the journey towards the resolution.